Hello everyone, my name is Rich Lenkov. I'm an attorney with the law firm of Bryce, Downey, and Lenkov. We are a Illinois and Indiana firm. We're based in downtown Chicago. We have 30 attorneys. We cover a wide variety of practice areas, including workers' compensation defense, products liability, employment law, corporate transactions, real estate law. We've been around for 12 years. I head up the firm's workers' compensation department. I also handle products and personal liability. And we are also a very proud member of the Illinois Manufacturers Association. I am here today to talk to you about Illinois workers' compensation, medical marijuana. So specifically, we're going to give you an update on the recent statute involving medical marijuana and how that might affect your workers' compensation program. So as a brief introduction, back in June of 2011, Governor Quinn signed into law a sweeping reform of the Illinois workers' compensation system. As a brief background, I'm sure you're all very familiar with the difficult environment that manufacturers and other employers face in Illinois when it comes to workers' compensation claims. Many consider Illinois to have among the most liberal venues in the country when it comes to defending workers' compensation claims. So in the months and years leading up to the governor signing into law this reform package, there was a lot of talk about companies leaving our state. Some pretty prominent companies talked about leaving if the reform didn't happen. In addition, there was a variety of scandals and some other issues involving the Workers' Compensation Commission that finally led to House Bill 1698 being signed into law by Governor Quinn on 6/28/11. Now, this reform package covered a wide variety of areas, things like preferred physician panels and AMA ratings were applied to Illinois. One of the other things that was changed as part of this act was intoxication and impairment. One of the provisions of this act was to make it easier for employers to defend workers' compensation cases when the employee was impaired, either by drugs or alcohol. So I'm going to give you a brief overview of this reform as it applies to intoxication, and then we're going to talk about the most recent statute involving medical marijuana in Illinois. So in terms of the Workers' Compensation Act, for accidents that occur on or after 9/1/11, if you have an employee who incurs an accident at work and you have evidence that they were impaired either through drugs or alcohol, it is now easier for us to defend that claim on a workers' compensation basis. Now, why is it easier? Well, the Act strengthens our defense by creating a presumption that if an employee is either impaired or intoxicated and they injure themselves at work, the presumption is now that the alcohol or drug use was the cause of the injury and not work. So that's a presumption that we now have as a result of this statute. Now, it's a rebuttable presumption. What does that mean? The burden shifts to the employee to prove that it was work rather than the drugs or alcohol that was the proximate cause of their injury. We don't have to prove anything as the employer, as the respondent. We get the benefit of the presumption that as long as you have a positive drug test or alcohol test, then that was the cause of the injury rather than work. It's still a rebuttable presumption, again, meaning that the employee can provide evidence to the Workers' Compensation Commission that despite the fact that they were impaired, that it was work rather than their impairment that caused the injury. But it's a fairly high burden to prove. There hasn't been any case law since this change has been made to give us guidance as to what that means. But again, it is up to the employee to show that the impairment was not the sole proximate cause of the injury. So what does that mean as a practical matter? If you've got an employee who injures themselves and you have evidence of impairment or intoxication, either because you have a positive drug test or some other evidence, then that is a case that you should deny. The burden would then shift to the employee to prove why that work accident was compensable. As a practical matter, most of my clients, I've been doing workers' compensation in Illinois representing only employers, only manufacturers for almost 19 years. Most of my clients, even before this was enacted, would deny those claims anyway. You know, even if someone was a little bit impaired, most of my clients felt that that's not the type of employee that they want to pay. You know, that's a pretty suspicious claim, even if someone is a little bit impaired. So as a practical matter, these are claims that you want to fight. As a further practical matter, if you are going to fight these kind of claims, it's important to remember that as from an evidentiary perspective, from a trial perspective, the positive drug screen or the positive alcohol test is not going to be in and of itself enough evidence for us to proceed. If you are going to fight these, which I encourage you to do, you're going to need to have that positive drug test or positive alcohol test confirmed by a toxicologist. You need to go that extra step and have it confirmed by an expert, because in and of itself, a positive drug test doesn't necessarily mean that person was impaired. So that's the workers' compensation piece of it. In terms of the recent reform or the recent statute, on 8/1/13, Governor Quinn signed into law the Compassionate Use of Medical Cannabis Pilot Program Act. Medical marijuana basically has been legalized in Illinois. While it was signed into law again on 8/1/13, it takes effect on 1/1/14. What that means is that Illinois citizens are going to be able to legally purchase marijuana as medicine by around mid-2014. What are the implications for your workforce? Well, what this means is that patients can receive up to 2.5 ounces every 2 weeks from a dispensary. There are 40 conditions that a patient can have that will allow them to use medical marijuana. That being said, the law is more restrictive than many states which allow marijuana use for catch-all categories like chronic pain. The qualifying medical conditions are in front of you. There's a wide variety of them. In addition to these, the Department of Public Health can approve additional medical conditions. Again, as a practical matter, what does this mean for you and for your workforce? Can you prohibit marijuana use during working hours on work premises? You can prohibit marijuana use during working hours or on your premises. The exception, of course, might be where the employee proves that their drug use, their marijuana use, is for a medical necessity, for one of the qualifying conditions that we talked about. If they can prove that, I suspect that they'll be allowed to use it, again, on a reasonable basis during work hours. We don't know how that's going to play out because it's a brand new law, but I suspect that'll be subject to some litigation. Second question, can you fire an employee who is caught working under the influence? Yes. It's very important that you have a drug policy in place. And as in the case of other illegal substances, an employee who is caught using anything that violates your drug policy should be terminated. Now, again, if the terminated employee can show that they're using a substance, marijuana in this case, that would otherwise be qualified under this act, then they might have a case. Again, we'll see how that plays out as this litigation develops. Third issue is, can you reject a job applicant for a positive marijuana test? Yes. In a conditional hire situation, You may ask an applicant whether he or she uses any prescribed medications that may preclude them from performing the particular job position for which you are hiring. You cannot ask applicants about drug usage that will have no bearing on whether they could safely perform the job, as that question might subject you to a HIPAA violation. So again, you can ask them the question as long as it's pertinent to performing the safety aspects of their job. Again, the extent to which the medical marijuana part of it will have on that question and answer is yet to be seen, because this is a brand new piece of legislation. Finally, can you conduct random drug testing? That's a little bit of a trickier one. The answer can be yes, provided that there is a policy in place, a reasonable cause for the testing, and a consistent and even-handed application of the testing. If there's no policy in place, however, a drug test can open the door to the employee filing an ADA and a discrimination case. Now that's a little tricky because without getting into too much detail about that, because that could be subject to a whole other discussion, if you've got an injured employee, they are qualified according to the federal government as a protected class under the ADA. And there are certain rules that you have to follow when you're applying a company-wide policy to them. Again, it's a little bit more involved than we have the time to go into right now, but suffice it to say that whenever you're applying a drug policy or any other policy to your entire workforce, it's important to be mindful of how to do that. And it's best to probably talk to your attorney about that. If you have any questions about that, in addition to workers' compensation, we have a very strong employment group. We'd be happy to answer any questions on this or any other issue that you have. My contact info is in front of you, and we'd be happy to answer any questions you have. Thank you very much. Appreciate your attention.